Court calls case of Lori Anderson versus Armani Lines. The email to the court, so that council's aware, it says, "Hi, this is Armani Lyman. My hearing has got rescheduled until today at 2 p.m. I'm in the hospital and will not be able to make it. I want to see if I can get another agenda." I will say, if council's not aware, I adjourned it to the last hearing because she had sent in medical indicating that she was in the hospital at that time.
Your Honor, my client is called the hospital. Miss Lyman was released on Sunday. And then here's the thing.
Wouldn't have given her that information.
Knowing Miss Lyman's the information.
Oh, God, really? You use somebody's information that you got for other purposes for the purpose of checking whether or not they were in the hospital? That is absolutely deplorable.
Still.
And inexcusable. Absolute excusable. Well, not going to benefit you today. I'm going to adjourn it. I'm not. I can't even believe you did that. Adjourn this to May 29th, 2026 at 3 p.m. Lori Anderson versus Armani Lyman. And here we go.
Good. At this stage of the eviction hearing, the landlord attorney explained the current status of the case to the judge. The attorney stated that the matter had reached a critical point because the court was approaching the legal deadline associated with the WRIT process. According to the attorney, the tenant had previously made a payment of $7,600 toward the rent balance that existed when the case was originally filed. However, despite that payment, a remaining judgment balance of $4,107.37 was still outstanding.
Good evening, Your Honor. Lori Anderson. All right, where are we on this?
First and foremost, I would like to state that.
Hold on a second. Why do I have this case? Because.
What I've got, 457.
Which one? All right. Go ahead. What do you want to say?
I was going to say that she has been using my personal information to impersonate me, and she's still harassing me. But apparently, the neighbors have been telling me that as well.
I'm here on a WRIT hearing.
Your Honor, from plaintiff's perspective, if I may, this is a WRIT hearing. We are coming up on the 56-day time period issue. As of our last hearing, we acknowledged that the defendant had made a $7,600 payment towards the rent that was owed when this case was filed, leaving a balance on that particular judgment of $4,107.37. The court was adjourned that so that that amount could be tendered to the plaintiff. Thus far, we don't have those funds. And furthermore, Your Honor, there's currently another 3 months worth of rent due.
Are you going to pay off this judgment?
I'm sorry, what did you say?
Are you going to pay off this judgment?
I'm going to pay it, but it's not right. I would like to go over it because I do not owe that much.
Okay,
there that I would like to look over and see something about repairs, but nothing was repaired. So I'm trying to see where the extra money is coming from. Still paying the warranty.
Lyman, this judgment was issued in March.
I have $6,600 to pay, but I would like to see everything before I pay it, so I just don't need.
That's the judgment. I'm not disturbing the judgment.
Well, it's not right at all, because I should only hold $1,000.
I'm not disturbing the judgment. Judgment is what it is. I don't have anything filed indicating that I should even look at that judgment. That's what the judgment was issued for. I'm now in May. If you pay off the judgment, they got to figure out what they're going to do.
During this portion of the hearing, the judge focused on one key issue: when the outstanding balance would actually be paid. The judge repeatedly asked the tenant for a specific payment date, explaining that the rent obligations continued to increase with each passing month. The court noted that even if the tenant managed to pay part of the balance in the near future, additional rent would already be due by that time.
So I emailed the court the day of with that, saying it wasn't right.
All right, let me just be clear. I'm not doing anything with the judgment. You can keep talking to me about it if you want, but I'm going to tell you the same thing. So your choices are: you either pay off the judgment, or I just deny this and they're going to go forth and do what they got to do. So which do you want to do? There is, you said 4107
37 on
on the judgment.
the judgment.
You said 37 or 40?
$4,107.37.
Okay. I think we were starting at the wrong one. All right. Are you going to pay that off? When are you going to do that?
66 that I can turn in next week.
Well, I can't. Lyman, I thought you said you had 66. Do you have?
I've been in the hospital.
Okay, I got that. I understand, and that's why I adjourned the proceedings out. But there's about 4,000 that's owed on the judgment. When is that going to be paid? Because the writ, Ms. Lyman, understand, the writ is sitting here in front of me right now. When is it going to be paid? Because I'm assuming if you pay that next week, and if I remember the rental rate, it's about 3,300 or something like that, it's going to go up again. They're just going to begin the case again. I mean, but that's not where I am right now. What day next week are you going to pay this?
Say,
I can't. That's not even next week. That's the week after.
we'll have it till the 8th.
And at that point, they're going to be 4 months, right? Is that right, counsel?
That is correct, Your Honor.
So then I'm going to be what, 12 plus, well, I'm going to be about 13,000 behind at that point. Simon, I can't continue to do that. I don't mind giving people an opportunity to pay and catch up, but I can't do it. So, the way it works is that I'm signing the writ, I'm issuing the writ, I'm denying the motion to stay the eviction, or I'm not staying the eviction. The writ is signed. If you pay it prior to the execution of the writ, then fine, but otherwise I'm not doing anything else. I can't, in good conscience, do that. So, thank you. Ann's gonna need that. Haverhill on Clark versus Sylvia Amory Brewer.